invention. Okay, now you can see there are a lot of funny patents also. Unusual invention, hard gesture patent. Okay, Google Glasses. You see the software related patents are there. Next slide. But they fail somehow. Not all patents is successful. You see the pager. You know that example of pager. We are way ahead to it. Epic fail. We don't need it now. But there might be a usage for pager in future. How? You are being hacked, right? There must of spamming because of internet. Pager is not based on internet. We can still use it. That's the beauty of IPR. You can earn a lot. It is sometimes said that let my chair burn, let my table burn. What remains is but the name. Now, banana protected device, a patent was granted for banana shaped, designed to keep banana safe during travel. The point is that if you don't have a science background, can you patent? Yes, you can. Just give idea to some broker. They are going to make you the stakeholder. Most of the patents, even I heard of 7 patents. I am not a technical person, but I gave them the idea. I am the stakeholder and I am earning the royalties. Okay, let's be secret. Let's have a secret thing about it. Why tax issues? Okay. Now, yeah, next slide. Okay. How to protect your IP? Identify what needs protection. Learn the IPR hand signals like legal steps. Consult with lawyers, IP lawyers, very important. Now only fifth year knows over here. That's what I'm talking about. I'm not talking about just creating a child and leaving it in jungle to be raised by bulls, but then how to raise the child, how to manage the child, how to value the child. This is the important thing. This is a bit complicated, but then it's just an awareness workshop. So let me tell you, Harvard University and Singapore University survives on the income base generated by IPR. Okay, they don't survive by tuition fees. No, they are not. They are having their articles published, which is being commercialized. Right, many projects are owned over here. So you see, there are many authors. You know about them. Arundhati Roy. You know about this Kafka. You heard of a great novelist also there, like. What is the name of that? The author of The Alchemist, Paulo Coelho. Right? Yeah. Now, most of the renowned authors do get Booker's Prize, they do get Nobel Prize also, like the Soul Mountain. You see, but then there are some authors who serve only the taste of public, having no literary merit. Okay, there are some, yeah, and most of them are trendy. So, yeah, what are the problems? Wrong name, choosing the wrong name.
Can we mention the names of those authors also?
No, not necessarily. But I'm a critic of such authors who don't uphold the literary merits, personally speaking. It is my personal opinion. It is not a defamation, it is just a personal opinion. And I guess in our country, free country, we can criticize because we have bought it. And it is in my cabin. So yeah, that has been my mistake. Yes. So monitoring the competition. You see, a startup neglected to monitor their competition's IP filings, missing out valuable market intelligence, potentially allowing competitors to exploit their technology. If you don't watch your steps, you are doing infringement. You will just study infringement, so don't worry about it. Infringement is very easy to learn. If you are plagiarizing things, you are infringing. What is plagiarism? Riding upon others' work, directly or indirectly. So, yeah, that's next. Okay. What happened? A gynecologist faced a dispute with hip hop star Dr. Dre with their similar names for selling audiobooks. Trademark office dismissed Dr. Dre's case. These things happen. You see, you are using someone's popularity. Celebrity rights is a new concept in IPR. It says that some celebrity, in the name of Shah Rukh Khan, you are just booming up your business. Shah Rukh Khan also deserves some money, right? So IPR is about commercialization and sharing of benefits and also rights of authors. Elvis Presley versus Brew Dog. These big names are there related with IPRs. IPR dispute is a day-to-day business. And let's see, misconception, only big inventions need patent. The small inventions. I will give you an example. COVID-19 era came and people were looking for this bioscanner, auto scanner. These were also patented. Okay. Even innovation patent is there in most of the countries. You simply refurnish it. You make this water bottle cap full with some flavors. Okay. Innovation is done. Make it edible. Invention is there, but then you are having innovation patent in some countries. India has it only in pharmaceutical sector. Does not even have it in all sectors. Copyright protection is automatic. Well, this is not a misconception actually. Let me tell you, it is reality that copyright protection is automatic. But then evidence, for evidence purpose, registration is important. For supplementary. The misconception can be like copyright can be, you can have copyright in anything, just a slogan. This is a misconception actually. Okay, that cheetah bhi pita hai. No, it is not a copyrightable material. It is just a part of trademark. Okay, so idea doesn't affect personal use or hobbies. Yes, it does affect to some extent. So mythbusters are many. We have listed a bit. Copyright in digital age, very much of a headache. Why? Because plagiarism is a day-to-day business. So detecting the plagiarism is quite a complicated task. Okay? Now, what happens that when plagiarism is there, you are having multiple contents with identical kind of realities, like the Dil Tukne Wala Shayad. Any shayad sab author makes no sense. It's a nonsense thing. Sometimes when you say like Chand Gol hai, should not be copyright. Chand Gol hai bhai, it's a truth. So truth cannot be copyright protected. But when you say that Chand ko dekh karke roti ki yaad aati hai, now that is something which is beautiful. That is subject to be copyright. To see the literary merit, we don't have any system to adjudicate the merit. We simply have the system to know whether or not you are copying the truth, whether you are reporting the truth, or you are adding some substantial thought over it. So idea is not protected, of course, in copyright, but then concept may be protected if concept is well presented. Famous sport battles. So you see this monkey selfie case, you will just Google it, but this monkey actually took a selfie. This monkey took a selfie. And there was a big dispute in America whether this monkey is the author or not. Of course, these people don't have, that monkeys don't have much rights as human beings do. They always depend upon the custodian. So, yeah, guardian of the Jew was given that benefit. Okay, you are that, of course, you are the guardian. You can look after that monkey with that money which is generated out of this selfie. Google LLC versus America regarding software interface and fair use of software. Now, the copying of software is also very common. Now, you see, it's just type Kundli software, you will get 17 or 18 kinds of software generating similar kind of Kundlis. But then their interface is different. User interface. So that user interface is something which actually gives you the competitive edge. Future of IPR, what's next? Who knows? ChatGPT. It is a very smart generator. So actually, IPR, there is a sad news, there is a bad news, but there is a good news also. Good news is IPR promotes innovation. The bad news is the open source softwares, open source knowledge. If you are preferring knowledge over commercialization, it is a bad news. Because then Wikipedia provides you a lot of content to study, free of cost, which of course affects what? Authors. And if you are having compulsory licensing, it affects those businesses who invest millions of dollars in development of a drug. So yes, there is a demotivation also, there is a motivation also. But monopoly is beautiful in the end. If you see this McDonald's, it is maintaining its beauty. It can charge, it can overcharge because it has the quality. It doesn't stop anyone. You can have the quality, right? So IPR also promotes innovation in one way or another. But then this IPR range is very dynamic. We need to have our pace, maintain our pace to run parallel in this world. Why? Because see, you have to beat ChatGPT. Otherwise, ChatGPT will take over even academics. Now that is the problem. Why? Because if you are given all sort of knowledge and you don't have a skill, how to utilize that knowledge, how to utilize your brain. Because the name of IPR is intellectual property. Intellectual. If it does not come from you, it's rubbish, it's garbage. If it is coming from anyone else, it's just copy. You just imagine what will happen to our future if each and every if on a particular topic there will be similar kind of content. We need variety of content in order to promote innovation. So future of IPR actually depends upon. Thank you.
Thank you, sir, for the wonderful presentation. So, guys, I'm going to share your views, share your ideas. So, any question regarding this, you are free to ask. Yes.
हेलो सर आपने बताया था कि है ना मुझे कंटेंट्स एंड रील्स एंड पे आईपीआर नहीं तो वो डिस्टिंक्शन बहुत फाइन होगी तो वो डिस्टिंक्शन कैसे होंगे
Repeat your question.
सर आईपीआर मटेरियल्स और नॉन आईपीआर मटेरियल्स के बीच का डिस्टिंक्शन आप कैसे समझ सकते हैं
Okay, very good. I have the mic. Okay. There is one thing that we need to understand the source from where the particular content is coming. If you talk about it, okay, that is a common license, free to use, but then it is easily editable. Now that is something which we cannot use in academics. Okay, in academics we promote your intellectual skills. If we talk about assignment, anything, we talk about your input, which is more important. Now, if you go for subscription, okay, where the articles are there and where it is not plagiarized, then that is deemed to be the original content. But I have a question. Skipping plagiarism does not make a content original, essentially. It is just escaping the plagiarism. Okay, so original contribution, if you need to research on that. You see, ssrn.com, it provides you with the various articles. But then if you go to some other websites to get your law articles, then it is not reliable. It can be published by anyone. So without having that qualitative analysis, the same problem exists with the Copyright Office. That it does not essentially filter the content, essentially research the content as Patent Office do. So there is a problem with that. You need to deep delve into the source from where it is. Another question is yes.
What are the current loopholes in the existing laws related to the IPR area?
The current loopholes is that basically the penal provisions and the provisions with regard to search and seizure is outdated because most of the plagiarism and most of the copyright infringement is on cyberspace. Our IP Act needs to, needs to make the relationship with our IPR laws more strong. That bond has to be strengthened. Otherwise, there will be loose ends. Like if you see copyrights anti-pillar order, or if you see any other order, it is about search and seizure. What you are going to search? There is no territorial jurisdiction beyond country. So India is having limited territorial jurisdiction. So on internet, you see the morality, the issues. We are not able to decide what is our moral standards. You see, the Netflix is of course representing those movies which are not appropriate for most of the viewers. So I'm not talking about infringement. I'm talking about other societal challenges that is attributed to which our act is not yet ready. Any other question? Yeah. Ask. So
I think that we do not lack in ideas. First, people do not take initiative. ऐसा नहीं कि आइडियाज आते नहीं है लोगों को, बट दे डू नॉट एक्ट अपॉन। तो सर कहाँ लगता है आप लोगों के वहाँ कहाँ ये प्रॉब्लम कहाँ
The problem is at home. The problem is at central government level and the state government level, because that awareness has to be done right from school time. That your ideas are really important, and you actually I remember correctly when I was myself 6 years or 7 years old. I authored a poem, and my father got it published. Right? So, and my first book is published by my father only. Use of the publisher. So it depends that you are not motivated because you are not earning. Why you are not earning? Because you are not rightly directed how to earn. Once you start earning from a book, a poem, a song, the moment you are going to realize its importance. And what happens that you author an article, you put it in some website, and nobody cares about it. So it's right. So it just becomes khanaputi. Even in your CV, in most of the academician CV, they are not actually earning from their article and their books which they are publishing. That is where the demotivation starts. And it is the work of the government to make awareness right at the root level. Right. So this is very important because you are not earning. You see, why in movie industry, Bollywood industry, people are so eager to bring up new movies because they are earning, right? So IPR's motivation is in commercialization and right guidance. Of course, we need adult education in the schools, but then we also need IPR education in the schools. Because right now, if I see first year or second year students, substantial amount of projects they do are copying somehow, right? I mean, I have to resend it. I have to say, request that kindly send it again. Why? Because they don't have that awareness at the school level. If they are not in IPR honors, they are certainly unaware about IPR. And even our family members, they don't know much about patent or copyright or trademark, which is actually important. Because make in India does not mean manufacture in India. It means actually to innovate in India first. So innovation is the first stage where you need to promote it.
So suppose there are two individuals who want to patent the same thing and both claim to be the inventors of the same product. Then in that case, who gets to have the patent? Also, please tell me who decides that who gets to have the patent?
Okay, wonderful. Actually, this never happens. What happens is that India follows first come first serve basis. Okay? And two persons having similar idea, but who has come first? Right. And those who have come first, right, they will always get priority. Huh? But then the knowledge, if it is there in public domain, let's suppose that you are having a fine idea for regarding an invention and you presented it in a paper, you have authored it in a book, then you are your own enemy. Then you patent cannot be granted. So this clash actually never happens. Now, let's suppose you are taking example of USA. In USA, you have to prove your inventorship. Here you have to declare, I am the inventor. It is your duty to search. In USA, it is your duty to search. You have to prove the inventorship. Like, let's suppose that I have an idea that I will make a car. Let's imagine that there is no car in this world right now.
Flying car.
Any car, flying car, any car, flying car. I have the idea, you have the idea, right? But then I have a substantial idea about how to construct it, how to design it, and I generate my specification with that regard. So complete specification is ready with me, provisional is ready with me, and I rush to the office. Right now, I have created a precedent. You, if you come later, I have created a precedent, so you will not be granted with it.
सर एआई जनरेटेड इमेज कैसे पॉपुलर है?
Hmm?
एआई जनरेटेड इमेज कैसे पॉपुलर है? इसका पॉपुलर
Copyright is for any literary work which is arranged in a way which is different. It's a dictionary, right? All are having similar words, but explanations are different. They all dictionaries have copyright, right? AI generated emails, you have to see that you need to paraphrase it. If you want to protect it, if you want to ensure that it is original, you need to paraphrase it. And for most of importantly, I don't promote the paraphrasing. You need to add your own input. Your input is more important. Presentation is more important in content, right? Not the idea in itself. Now, there was a famous case, New Delhi case, New Delhi case, R.T. Anand case. This is all about this, that I told you some story, you made, you produced a movie, someone is having a natak. So, substantial similarity is seen, it's a layman observer test. By that one, this principle can be allowed, there can be followed here also. Where the email is similar, like let's suppose that I drop an email to my employer that I am sick, I cannot join today, I will join tomorrow. Now, this is a very common, right? It cannot be sought copyright, even if it is AI generated. It makes no sense, copyright. You cannot just copyright and daily business conversations, right? You have to think about some merit output, what output readers are going to get out. Yes, any other questions?
What is the role of IPR in the defense equipments and how it can be related with another
In
defense equipments and how it can be related with other field of laws like constitution or law?
defense equipments. Well, you are talking about then section 4 and section 3 of the Patents Act, of course, we cannot go further. It's a DRDO's responsibility anyway. So this is not open to citizens. Okay, and if you talk about drone technology, right? Drone technology was not patented in India. Of course, it is being commercialized nowadays. Now, this is the danger of patent. Drone is used to harass and stop people, right? Nowadays, mostly. Apart from weddings, it is being used for unscrupulous purposes also. So this is the side effect of say IPR. Very much a side effect. Biochip was invented prior to the mobile phone. It is not used in mobile phone. So that you have a disease, brain tumor, you go to the hospital and hospitals charge you and hospital pay the tax. You are able to some money.
So, perhaps being an educator, I would like to ask that there are students from first year and second year. So how they can build a career or why they should consider IPR as the option?
That is why secondary event is there. That is the reason. First, they feel that they are the right? And they are making shots, but they are not actually commercializing. I promote that. You need to commercialize, find platform where you can sell your photo. There is one or two many app to sell your photos. Just rush into it. Don't think that you are something ordinary. What happens that I used my daughter's Ajib Garib kind of drawings and I sold it for $80. Yes, people like it. And you know who bought it? Someone from France. You see that what an aesthetic beauty it carries. The review was there. It was nothing, it was just on wall. You know, you just don't need to Leonardo da Vinci, not Da Vinci for that. Yeah. One point is that anything you can calculate, you can document something, you can just go for it. And earn from it. So that is, you're not selling it at a high price. That's the point. Yes. Any other question? Okay, so let's start with the event. Bring it on. Thank you.
Good morning, sir, respected educators, and my dear participants. I, Soumya Mishra,
And I produce prefer.
want to take a moment and express my heartfelt gratitude to Saurabh Siddharth sir on such an insightful speech on IP awareness. Your speech has truly resonated all of us, reminding us the importance of IP awareness. Now, let's move towards the IP trivia competition.
The rules and regulations of the competition are as such. The participants the participants who have registered for the IP awareness session are eligible to participate in this quiz, in this competition. There are 20 MCQs questions and 25 minutes will be allotted to each participant. Time alert will be issued at the 15 and 20 minutes mark, and with a countdown commencing with there when there are less than 10 seconds remaining. The participants with highest vote will be declared winner by the judges, that is our educators and organizing committee, and their decision shall be final. The participants are required to follow the rules and regulations and please maintain the discipline and decorum of the event. Thank you and wish you all the best. May the best win.
Link is being shared in the participants IT awareness workshop group just in a while, okay? 2 minutes only.
Some participants